Next on the agenda today, gentlemen, is our legal update from David Creais, our Honorary Solicitor. David.
Morning, Bev. Morning, gentlemen. So I realise we're a bit short of time today. Lots of presentations, so I'll be relatively brief. Legal news. Well, I suppose the most recent bit of legal-related news, of course, both political and building-wise. Bob Day, Family First Senator, who has resigned from the Senate over the collapse of his business Home Australia, which runs the Huxley Homes brand in New South Wales, gone into liquidation. I think there's I heard about 200 homes in the course of construction being frozen, so have to keep our eyes out to see what happens with that, whether someone comes in and buys that part of the business out from the shell, or what happens. No doubt there'll be a few inspections that need to be done on those Huxley homes to clarify where they're up to. Remembering that the Home Building Compensation Fund, in respect of incomplete work, only covers you for 20% of up to 20% of the total cost of construction, and of course there's also the $340,000 total limit on what you can claim under the Home Building Compensation Fund. So it may well be that there are some homeowners out there, unless someone gets together some kind of scheme, particularly aimed at those 200 homes, who will want some inspections done. Now, perhaps coincidentally with Cole's presentation in talking about compliance with standards and also liability, I thought I'd just briefly recap something I'm asked from time to time is what obligation is there on an owner to bring their property up to standards. If property's been built, say in the 1980s, complied at the time but doesn't comply with the current standards, what's the obligation for that owner to bring the property up to standard? Well, the short answer is that if the building complied when it was built, there is no absolute obligation to bring it up to the current standards. And if you don't bring it up to the standards and someone is injured, that doesn't automatically mean that you've been negligent and that you are, as an owner, you are liable. It's also not a blank cheque to say that you don't have to make some improvements if there is a known danger, and that's what it's really all about, whether there's a known danger. I guess the starting point, so far as the current law is concerned, is a case called Jones and Bartlett, which was decided in the High Court in 2000. Very briefly, that was a case where a family were leasing a residential property in WA, and the young son managed to put his knee through a glass door inside the house. The glass door was 4 mil, the glass in the door, 4 mil thick, annealed glass, shattered fairly quickly. However, at the time that the property had been built, that complied. There effectively wasn't any real standard. That was practice. At the time of the case, or rather at the time of the accident, more importantly, the standard was 10 mil toughened glass. So the parents, on behalf of the child, brought a case against the landlord, said the landlord had an obligation to make sure the house was safe, and that meant complying with the standards in force at the time, not at the time of construction, at the time of the accident. The High Court said no, that's not the way it works, and said in terms there's no such thing as absolute safety. All residential premises contain hazards to their occupants and to visitors. Most dwelling houses could be made safer if safety were the only consideration. The fact that a house could be made safer does not mean it is dangerous or defective. Safety standards imposed by legislation or regulation recognise the need to balance safety with other factors, including cost, convenience aesthetics and practicality. The standards in force at the time of the lease reflect this. They did not require thicker or tougher glass to be put into the door that caused injury unless, for some reason, the glass had to be replaced. So in other words, if there's a replacement, if you need to do some work for some reason, the new work has to comply with current standards. But unless there is a clear and obvious danger, you don't have to bring old work up to new standards. And one of the things the High Court observed in relation to this particular house was there hadn't been any problems previously. There'd been no instances of cracking windows. They said there was no particular reason for having the house inspected before the lease was entered into. That was one of the complaints of the plaintiff. They said the owners should have had the house inspected before you let it to us. High Court said, well, unless there's a particular reason to have the place inspected, no, that isn't part of the duty of care. So that case is the modern, I guess, benchmark for issues of that kind. Now, however, the court did say, is there a duty of care? There is no answer which is of universal application. Deciding what the answer should be in a particular case involves a factual judgment and does not provide the occasion for the imposition of a requirement of the law. So in other words, there's no absolute rule. It does depend on the circumstances. Now, probably the latest case in New South Wales anyway, Supreme Court case of Schneider and AMP Capital Investors. Now, this is a case where the plaintiff said she was injured when she got out of a lift. She was actually a property manager working in this particular high-rise building in the city, and she got in the lift. She went up to her office floor. The lift failed to level properly, so there was a bit of a lip between the floor of the lift and the outside floor, and she tripped over that. Fell down and injured her back and brought a claim against the owner of the building, saying that the lift wasn't safe. Now, apparently, when the lift was installed, and that was back in the 1970s, so it's an older building, when the lift was installed, it complied. The regulations didn't require lifts to be upgraded. Unlike the Jones and Bartlett case, there had been an inspection. So there was an inspection done of the lifts in 2006. This accident happened in 2008. And in the assessment, the report said that there was a high risk that the lifts would not level to within plus or minus 10 millimetres, and the replacement of the controlling mechanism with a regulated drive, whatever a regulated drive is, I don't know if we've got any lift engineers out there, would be required to address this. Now, yes, they could have addressed it by putting in a regulated drive into that particular lift and the other couple of lifts in that lift bank. The cost of doing so would have been $475,000. Now, what the court said was, well, the evidence didn't show that upgrading of lifts to the newer technology was the norm in Sydney high-rise buildings, or that it was a practice that had been so widely adopted as to engender an expectation on the part of the general public that all lifts would operate to the standard of levelling achievable with the post-1983 technology. Given the low probability of an out-of-level step being of such a nature as to go unnoticed by a reasonably careful alighting passenger, so throw it a bit back on the actual individual, replacement of the entire lift machinery at a capital cost of $475,000 would be vastly beyond the requirements of capital investors' duty to exercise reasonable care to protect a passenger such as the plaintiff against the identified risk. Good news for owners and for owners and those who occupy and lease. Not so good if you are a visitor or perhaps a worker. Again, each case turns on its own facts, but importantly, if it doesn't comply with current, but it did when it was built, that's not going to be evidence of negligence. You have to show that there's a real risk that should have been addressed and a risk that was known to the owner or the person who is occupying it as lessor. So that's where the standards are. That's so if you're asked by any of your clients, you can give them that answer. But of course, if in your inspection you identify a real risk, well then the answer is, well, you now know about this, you've got to make up your own mind as to whether you need to address it or not. So it's a bit of a minefield. Of course, lawyers love that because we get more work out of it. But, so there it is. Now, I like from time to time to give you a little bit of an idea of some of the curiosities of the law. This one, I guess you'd say only in America. Just look at their election race at the moment. The title of the story is Polly Want a Witness. What happened was, well, in summary, a dead man's parrot could become a key witness in a murder trial. This fellow was killed in 2015. He was murdered, and initially the police thought that there'd been an intrusion, so break and enter, and he'd been shot during the 5 times he was shot actually during the course of the break and enter, and certainly that was what was suggested by his wife. However, it would seem that, and it doesn't go into detail, but reading between the lines, it seems that, and this is his second marriage, that in his will he must have left his African grey parrot to his ex-wife, probably to annoy her, I don't know. But it turned out to be quite significant because his ex-wife claims that the pet African grey parrot witnessed the whole event and could provide key evidence for the prosecution. She said 2 weeks after the incident, Bud is the name of the parrot, started going into rants I couldn't explain, screaming, yelling, and always ending with, "Don't effing shoot." I believe with all my heart that those are pretty close to the last words of Marty. Marty was the guy who got shot. Video footage exists of the bird squawking, "Don't effing shoot," and the prosecutor says that it's now likely that they will charge the wife with his murder, and prosecutors haven't ruled out using the video footage of the parrot screaming, "Don't effing shoot," in court in the case. So there you go. Thank you, gentlemen.